provide good guidance and precedent for nation building. Unfortunately, every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy. The second reason for making the statement is, though I'm in the process alone, its effects ripple far beyond me as a person. This process will affect how all Superior Court justices and future Chief Justices may be removed from office. It also affects commissioners and heads of independent constitutional bodies set up to protect the freedom and justice of Ghanaian citizens as guaranteed under the 1992 Constitution. In building Ghana's democracy in the Fourth Republic, the framers of the Constitution identified public officials who must directly serve the citizens of Ghana without being afraid of unjustified punishment or reprisals from influential people or members of the executive or legislature. The framers of the Constitution identified that only when these public officials we can work without fear, control, or at the pleasure of influential people, that freedom and justice will reign in Ghana. The law did not provide for the termination of their appointments by any authority. The Constitution set up grounds and processes for removing them from office under Article 146. And these grounds must reach the standard of, quote, inability to perform the functions of their office. The officials include, apart from Superior Court justices, commissioners of Traj, commissioners of NCCE, commissioners of EC, Electoral Commission, the Auditor General, and the chairman and the vice chairman and members of the Public Service Commission. The third reason for this statement is that in order to address the troubling violations of the Constitution and illegality of the proceedings that have become obvious to me, that became obvious to me from the beginning of the process, I started an action in the Supreme Court. I applied for the proceedings of the committee set up by His Excellency the President to be held in public, so that in the interest of transparency and for the truth in the matters being raised to be made known to the people of Ghana. I did so because I knew that the secrecy of the proceedings for removing justices was not created in the Constitution as a cover-up for any agenda. The Constitution expects that only reasons for removing the Chief Justice and public officials as set out in Article 146 will be the reason for doing so. And especially, such reasons must affect public sensitive national interest or public order or safety. I realize that in my case, should the public be made aware of the allegations in the petition, they would realize that none of the allegations made border even remotely on matters of national interest or matters of public order or anything that indicates that I'm unable to perform the functions of my office. An example is an allegation that I failed to retire accountable interest of $14,000 when I traveled. When I did retire that accountable interest 2 days after I returned from my journey, I was given $14,000. I could only spend $4,400, and I returned $9,600 2 days after I returned from Ghana, from my journey. And so I knew that it was necessary that the issues being thrown around as petitions against me needed to get into the public space. I swore to a supplementary affidavit alerting the Supreme Court also of human rights violations that I had started encountering when I went to the Article 146 hearings. However, the members of the Supreme Court that heard the application refused my application for the hearing in open, and they also struck out the supplementary affidavit at the request of the Attorney General. I have decided to make this statement today because the violations have not stopped. Indeed, they have escalated beyond anything I could have imagined as possible in justice delivery. These violations include the committee's refusal, in breach of the rules of natural justice, to recognize my lawyer on the first day of proceedings, simply because I was not personally present with him. And they went ahead to make arrangements for the hearing without involving my lawyer while he was sitting in front of them. The committee has also failed to indicate the specific charges that I'm supposed to be defending myself against in order to allow me to adequately prepare a defense to the charges. The committee has gone on to permit two of the petitioners, Mr. Daniel Ofori and Shining Stars, not to testify at all or present what case they brought to them at the hearing. The committee has refused to allow me to go into the hearing with any family member. Before you enter, there's a thorough search of my body and my handbag in violation of protocols and courtesies extended to any Chief Justice, which protocols and courtesies are honored in the name of the nation, both in Ghana and outside of Ghana. And then the work of the committee is being conducted in a cordoned high security zone on Castle Drive, Osu, when all Article 146 proceedings since 1993 have been held in facilities of the Judicial Service. It is hard not to reach the conclusion that the choice of venue against the backdrop of secrecy of proceedings is intended to intimidate me and to prevent any citizen of Ghana from knowing how the proceedings are being conducted. The Edu Lodge facility that the hearings are being conducted in featured very prominently in the planning of the murder of judges on June 30th, 1981. And this can be read about in the special investigative report on that terrible event in our nation's history. It will be recalled that there was a Major Samakwa, a military officer who was killed with the 3 High Court justices, who was the Director of Human Resource of GIHOC. He was my uncle and my guardian when I entered the University of Ghana in September 1980. I was also living with him at the time he was abducted and murdered. Was Edu Lodge chosen for my inquiry to make me feel insecure? I think so. And I continue to hold the view that there's no reason why a judicial hearing is being conducted behind the high walls of Edu Lodge. At this Article 146 hearing, no rules provided by law to regulate the fairness of hearings and trials in this country are being followed. As we all know, when a citizen is summoned before a court or any administrative or disciplinary committee, it is the duty of the committee or court to give the citizen a copy of the complaint that they are presiding over. You cannot be summoned without a writ, a petition, or a complaint. It is also the duty of that committee or court or tribunal to give copies of all documents that have been filed with them before the hearing is started. How does anyone defend themselves without a copy of the complaint that they have been summoned to come and answer to? This Article 146 committee has refused to give me copies of the petitions that His Excellency the President gave to them. They refused to give me copies, a copy of the prima facie determination that His Excellency the President is supposed to have given to them. They claim that they know that the President sent me copies on 27th March of the petition on 27th March 2025. And so they do not need to show me what the President gave to them. They also claim to have copies of the responses that I gave to the President, but they will not provide the petitioners with copies of my responses. The difficulty with this is, because they are the independent body charged with the duty to conduct the hearing, what I have in my hand from the President could be different from what they have. And I cannot assume that the two copies are the same. Indeed, no tribunal does that. No tribunal will tell you that before you came here, we know that your landlord wrote to you, so we are looking into what your landlord wrote to you about, and so that is what we will be inquiring into. They will give you what the charges are that they are supposed to be inquiring into. Second, the petition itself has not been admitted into evidence and subjected to cross-examination by me or my lawyers. In this case, because they have permitted the petitioner who has so far given evidence of whose petition we are supposed to be dealing with, Mr. Daniel Ofori, they have permitted him not to testify and confirm on oath what his petition is. There is no petition on the table. There is no evidence given by him on oath. He has not authorized anyone to testify on his behalf. So what are we inquiring into? Even though there is no constitutional instrument passed to regulate the proceedings of an Article 146 committee, Ghana has a constitutional instrument regulating the work of all commissions or committees of inquiry. This is the Commissions of Inquiry Practice and Procedure Rules 2010, CI 65. And in Article 1467 of our Constitution, if a committee is set up for the removal of a Chief Justice, the committee is supposed to, quote-unquote, inquire into the petition, the answer, and the prima facie case. Therefore, we are dealing with a committee of inquiry. In spite of this, on 15th May, the committee decided, without listening to my lawyer, that it will conduct the hearing not as an inquiry, but as litigation. So they rejected the use of CI 65, which was created for the regulation of inquiries, and said they will use the High Court Civil Procedure Rules, CI 47. Then they decided that each petitioner can conduct his case as he sees fit. So they don't need to present the petition to them. Then they decided that the petitioners can call public officials to confirm what they themselves have not testified to. So, ladies and gentlemen, because the proceedings are being conducted as if it is a normal litigation between the petitioners and myself, their lawyers now choose and pick which parts of the evidence that public officials present to put on the table. This is also in violation of known rules regarding proceedings of a committee of inquiry, because a committee of inquiry must have its own lawyer. And when it starts the proceedings, the petitioner becomes no more than a witness for the committee to prove the allegations that led to the setting up of the committee of inquiry. So the public officials who have been summoned supposedly on subpoenas without the issue of subpoenas just come and swear oaths and present documents to the committee as exhibits. The witnesses themselves do not have the petition. They do not know the allegations in the petition, and so they cannot answer questions on the petition. And when they finish submitting their documents, my lawyers are called on to cross-examine them. Since 23rd May 2025, this strange process has been followed up, and witness after witness has been called, like Nebuchadnezzar's situation, in which he demanded that the magicians in his court should tell him his dream and also interpret it. My lawyers are left to guess which allegations in the petitions that I received on 27th March are supposed to be the subject matter of the testimonies that the witnesses have referred to. Anyone who has been to the Circuit Court or the High Court and made subject to the rules CI 47 will know that those rules never conceived that a hearing can be conducted without the claims, the defenses, and the issues being carefully laid out before the parties and accepted by all of them before a hearing starts. Ladies and gentlemen, it is this total absence of compliance with all known rules of fair hearing that has caused my lawyers to file applications for judicial review in the High Court to declare all the proceedings void. Because the clear danger is that through this flagrant violation of CI 47 and the darkness of the current proceedings being held in camera behind the walls of a Lodge, my lawyers and I can come to the end of the proceedings. The evidence will show that every one of those allegations in the petitions that were given to me on 27th March is unfounded and untrue. And yet, the committee can dig up some allegation from whatever documents they claim to be having from the president, which they have not shown to me, and purport to enter a recommendation for my removal on that basis. Allow me to say that this is totally unknown in the rule of law in this country. If it was lawful, I would have no reason to alert the nation of the dangers they represent. It is the violations of law that have forced me to bring these matters out in the light of day. The final and fourth reason for this statement is that I have heard on several occasions from loved ones, persons who care, persons who may not know me beyond my public duties, and many who think that since these proceedings seem to be carefully staged to result in my removal as Chief Justice, it would be best if I just retired or resigned rather than subject myself to an ill-motivated process. I have also received threats and veiled threats to the effect that if I fail to resign or retire voluntarily, I will be made to suffer some harm or the other. I've also heard commentaries in the media about how this process was born out of a stated political agenda to remove me and control the judiciary, and that it is a political effort that can only result in an outcome that was decided long before it started. I thank everyone who has engaged in this conversation out of concern for my safety and well-being. Let me assure everybody that I am not seeking to cling to a title or a position. However, as a lawyer of 38 years standing, a judge of 21 years standing, and Chief Justice who has served the rule of law all my working life, in fact since I was 25, it is my onerous duty and obligation to speak up concerning anything that is extremely wrong with the administration of justice in this country. This is what I do every day. The situation I have been confronted with has shown me a model of injustice that I would never have thought possible if I had not been exposed to it. This is why, despite great personal discomfort, I have decided to marshal every effort in law and leadership to answer to this situation. Again, resigning or retiring while Article 146 proceedings are being conducted to remove a judge is not an option any judge or public official can even have. There is a decided case on the matter by the Supreme Court. The suit number is J6/02/2019. Again, no one has the authority to walk away from proceedings started by the state. Judgment can be entered against you because you failed to defend yourself. And a judge who resigns or retires would still lose all entitlements that they have worked for because they failed to defend the claims and resigned or retired while the proceedings were still going on. Therefore, if false claims are made against a judge or commissioner or other public office holder subject to Article 146 proceedings just to achieve a political agenda, the solution cannot be to resign or voluntarily retire out of frustration, pressure, or fear. You would only subject yourself to two cruelties: a judgment based on false claims and loss of everything you have worked for. It may well be that the efforts being made are intended to frustrate me so that I resign, so that the architects of the scheme can go back into the media and say that the wild and unfounded allegations were not defended because they were true and I had no defense to them. As Chief Justice of the nation, who has been given the privilege and obligation to lead administration of justice, I should not turn tail and run when I know the implications of not defending false and unwarranted charges. If I resign under these circumstances, I will be saying that this flawed, unknown, and opaque process is acceptable. It is not. Finally, let me respectfully say that the current bizarre proceedings I have brought to your attention present a twist to our nation's democratic journey that we all ignore at our own cost. My humble view is that Ghana has come too far in the 33 years of the Fourth Republic not to be concerned about the unconstitutionalities that have been designed not to affect just me personally as Chief Justice, but all judges and public officers subject to removal processes of Article 146, if this one is successfully carried out without being questioned. Behind me is every judge in the country. Behind me is every commissioner or head of an independent constitutional body in the country. If it's successful, it will be tried on anyone. I am not countering these processes for myself, but on account of the leadership burden that I carry. If the nation is willing to accept these developments in its democratic journey, it must be understood that I sounded the warning and the nation took the decision to be passive about it. I cannot share the burden of those involved in designing and implementing this enterprise of pretending to use Article 146 procedures to remove a Chief Justice through unknown and unlawful means, by keeping quiet about the violations of law and due process. Neither can I make anyone's burden lighter by resigning or retiring, instead of proving that not even one of these wild claims in a collection of petitions is even remotely true or meets the standard required for removing a judge. Now, allow me to take you a bit of your time to walk through these petitions. They have been in the public domain for some months now. They are actually available on the internet, so I'm not addressing anything that is not known in the public space. Many negative things have been said about me through public commentary on the petitions, although the petitions were responded to 7 days after I received them. And so anyone who cared to acknowledge my side of the story would have had no need to keep repeating the petitions without discussing them with the answers. And when I provided these answers, I also added with evidence to prove that each allegation was either a lie, a wrong opinion about how work is conducted in the judicial service, a wrong opinion on the work of judges, or a wrong opinion on the duties of a Chief Justice. I'll start with Mr. Daniel Ofori's petition. It is the petition with the most claims. Only 2 out of the several allegations he's making involve him personally as a court user. In one of those allegations, Mr. Daniel Ofori is urging that I should be removed as Chief Justice because I transferred a case in which he's a party from one judge in the High Court to another